You ask ChatGPT to write you a scary story, and it writes it for you. Who is the author of that story for copyright purposes? Is it you? Is it ChatGPT? Is it the company that operates ChatGPT? How about the programmers who created ChatGPT? Can an artificial intelligence system, a non-human, be considered an author under copyright law? I'm a technology and copyright lawyer, and today we'll explore these questions. Keep in mind that this discussion focuses only on the United States law. The applicable laws can be different in other countries. First, let's discuss works generated by AI with direct human input. This happens when you provide ChatGPT with some creative details about your story. For example, you describe the characters, develop the story plot, etc. In this scenario, you are the copyright owner, and AI is just a tool to achieve a desired result, as long as you contribute enough creativity. This concept dates back to an 1884 U.S. Supreme Court case. That case extended copyright protection to a photograph. The case involved a photograph of writer Oscar Wilde. The court held that the camera was a tool that helped the photographer create an original work of art. His creative contributions included the way he posed Oscar Wilde for the photo, the selection of lighting and costumes, and so on. How much creativity do you need to provide to ChatGPT to be the copyright owner? There isn't a precise rule, as each case is unique. I would say the more creativity, the better. Just keep in mind that mere ideas are not copyrightable. You need a creative expression of your idea. Before we proceed further, please subscribe to this channel and like this video to help me make more videos like this one. Now, let's consider an AI system as an independent creator. Let's say you merely ask ChatGPT to write you a story without providing any creative details. ChatGPT then writes everything on its own. Who is the author then? Can a non-human be an author? The latest guidelines from the U.S. Copyright Office state that works generated solely by AI, without human authorship, are not copyrightable. The office will not register works produced by machines or processes that operate without human creative input. Therefore, AI-generated works without direct human involvement likely fall into the public domain. What about the developers of the AI system? Can the programmers or the people who run ChatGPT claim copyright ownership? Probably not. This is because they didn't directly participate in the story's creative aspects. They created the machine that generated the story randomly. Those developers can potentially patent their invention, but that's a separate issue. Also, computer programs can be copyrighted as literary works, but again, that's a different issue. The main argument for granting copyright to developers is that denying it might reduce their incentive to create new AI programs. What about works for hire? A work for hire means the copyright belongs to a third party, usually the employer, rather than the creator. Could we argue that a work generated by ChatGPT is a work for hire for the people who own ChatGPT? This would allow the company that built ChatGPT to be the author of the AI-generated work. Essentially, ChatGPT would be treated sort of like an employee. The people behind ChatGPT would be the author. I think this approach makes sense, but it would require an amendment to the Copyright Act. By the way, how many of you have tried using AI to write stories or music? How did it turn out? Let me know in the comments below. Currently, there's no uniform solution for determining authorship of works created independently by AI systems, at least not the US. We need a legislative solution to address this issue. It's time for the Congress to recognize that, with advanced computer capabilities, humans are no longer the sole creators of innovative and creative works. What do you think? Let me know in the comments below. This video is for entertainment purpose only and not legal advice. Please subscribe to my channel and like this video.